Nancy and I are delighted to be here. We, kind of in our spare time, of which there's not much left, we do a lot of programs like this. We enjoy the opportunity to build awareness in wrongful conviction and let people know what we've discovered, what we realize about the justice system, what we think can ultimately arise in an injustice, and what we think we can do about it. And a lot of what we do is attempting to educate people, but when it comes to the ultimate punishment, this notion of wrongful conviction, of the innocent being convicted of crimes, even becomes obviously much more tragic in those instances where it's carried forward. I have a long history with the death penalty, and I'll touch on that in a minute. Partially because of that, I think the task force invited Nancy and I to appear last summer, not this past summer, but summer of 13, and we did so and talked a great deal about the growing opposition I have to the death penalty, in great part because of the risk of error. We learned very quickly that the justice system is not as good as we'd like it to be, and it makes mistakes. We'll get a chance to talk further about those elements and all the elements of it when we have the opportunity to speak more with our panel. I will tell you that my history with each of the panel members has been very rewarding in many ways, because they brought so much to the public side or the debate side of the issues in which they've been involved. Obviously, Bill Seitz, heck, I talk about him in the book we wrote, False Justice. I talk about him being instrumental because of a phone call he made in my introduction to wrongful conviction. I've referenced Terry Collins on a number of occasions, but I'll probably talk more about it because he and I...
He's in the book too.
He's in the book too. And he and I wouldn't see each other that often, as we both served in state government, but periodically we'd be on the phone together, and I'll get into that further. And more recently, I spent a lot of time on the phone with Kevin Werner, and the issues that he raises and the quality of his advocacy around this issue is very, very important as we rethink a policy that truly needs to be rethought. I had, in my time as Attorney General, an awakening. I call it an awakening to the risk of error in our criminal justice system, and accordingly, the prospect that innocent people were being convicted. We wrote a book about it. Nancy could describe to you an awakening she had in the middle of the night, kind of like a flash and a divine inspiration that this issue was important enough for us to devote a lot of our attention to, and her efforts in drafting a book that could really describe how we came to feel that our criminal justice system has significant weaknesses that need to be corrected and need to be addressed. And so the two of us have kind of stayed engaged in all of this. Good, we're on the next page, good. It says 1981. Most of you weren't born then, let alone serving in... Am I wrong? Come on now. Okay. In reality, 1981, I was serving in my first term in the Ohio legislature. I was a true freshman, but assigned to the Judiciary Committee. And the big bill that year was the death penalty law. Ohio had not had a death penalty since Furman versus Georgia, I think in 1972. And I actually was trained as a prosecuting attorney beginning in 73 and continued in that work. And we did not have any capital cases because we didn't have a law in Ohio. So I really had an opportunity to search my conscience. I believed that in a democracy, society through its lawmakers could determine that in the worst of cases, a death penalty could be appropriate. And I took that measure, but I wasn't absolutely certain as I entered into the General Assembly and that bill came before us within a matter of weeks. I wasn't absolutely certain what I thought about it and what I would do ultimately when it came time to vote. Ultimately, I voted in favor in our committee and then again in the House, and it was it had already passed the Senate, which was Republican in a majority, passed comfortably in the Senate, much, much closer in the House, which was controlled by the other party. But I made a decision to vote for the bill, arguing at the time that I felt that having a death penalty in Ohio could be a deterrent to heinous, horrific criminal conduct, and that it would save the public money because we wouldn't take the worst of the worst and house them for 40 years in our prison system. Obviously, I was dead wrong on both counts. It is not in the least bit a deterrent, and it only costs us enormously, both morally and in cash. I mean, when you really reflect on it, it costs a lot of money. But the bill was passed, as I pointed out. I voted for it in its final form. I look upon that as not a good thing for Ohio necessarily, but we watched a lot of years where we really didn't have to deal with it. At the end of his term, and of course, it would only apply to those crimes committed after the effective date of the law. So that effective date occurred in 1981. Actually, the effective date, I think, was January 1, 1982, as I recall. And at that point in time, it took years and years and years. Governor Dick Celeste had some that were in the pipeline, and he commuted the sentence, I think, of 8 individuals to life as he was leaving office. Candidly, I know George Voinovich did not support the death penalty. He never talked about it. But I don't believe that, as a matter of his personal faith, he supported the death penalty. And so he did everything in his power not to have an execution occur during his term. Bob Taft was elected governor. I was reminding Nancy that Bob and Hope and Nancy and I was already Attorney General, had dinner together at the governor's mansion, just the 4 of us, on Sunday night before the Tuesday execution of Wilfrid Berry. And I knew that Bob was agonizing over it. It's not an easy thing when you have that facing you within your overall authority, and Bob did. But he undertook to do it. It was Wilfrid Berry, as you recall, was a volunteer, but it was acknowledging his guilt and acknowledging that he felt that the punishment was not unjust because he had committed a very heinous crime. As the process went on, that occurred under Attorney General Betty Montgomery. I became Attorney General 4 years later. I'd said I was Attorney General when I was with Bob. I wasn't. I was Auditor of State. But I became Attorney General 4 years later in 2003, and was shocked to discover we had so many coming up. The first one that we undertook was a few months into my first year, and honestly, I was an emotional wreck after it was over. It was difficult for me. In advance of it, I would speak to the family of the victims, and I undertook that process through 18 executions. And on each one of them, if you wonder how the procedure is, because we were monitoring legal requirements, we were monitoring procedures, that's what the state's lawyers were expected to do. I was in a small room with a closed door with a direct phone line to this guy. Terry Collins was Deputy Director of the Department of Rehabilitation and Corrections at the time, and I would be on the phone with Terry, monitoring every step of the process. And I never thought it was easy, and I never liked it, but it had to be done. And so I learned more and more, and as time went on, because I came to realize that the reasons that I supported it were based on its deterrence and its cost savings, I came to feel that that was not a case that really applied, and I couldn't support it any longer. I left office. I found myself saying, well, I'm not really a death penalty supporter, and I feel that way today. And that feeling came about in great part because I came to understand that there's a great deal of risk in executing innocent people. Because I've come, and the part of our program that we're going to talk about through the majority of our presentation deals with the issue of wrongful conviction. The fact that we do, more than I ever dreamed, we do convict innocent people. And we will in the future, and we have in the past, executed innocent people. And that's kind of an overwhelming thought, but I know it to be a fact. As I became Attorney General, I gained authority from the General Assembly to take DNA from every convicted felon and first-degree misdemeanor. That gave us, in a matter of a couple years, a huge database of DNA which could be matched against DNA that was taken from crime scenes. And there were lots of crimes solved. I've got a couple mentioned there. I got a call one day from the sheriff of Orange County, California, and he said, I'd like to talk to you. He said, you guys just solved a nearly 40-year-old murder in our jurisdiction. I said, what about, tell me about it. Marla Jean Hires had been murdered in October of 1972. Her body was found rolled up in a carpet on the Loma Linda Country Club golf course. The police often suspected her husband, but never had any proof, never charged him. He went through the rest of his life with a big cloud over his head. What occurred in the solving of this case is we had begun taking all of the DNA from anybody in prisons or on parole, on probation in the system, and putting it into the National CODIS database. This was a matchup of someone in our system in Ohio against the crime scene DNA from Marla Hires' crime scene. The police in Orange County, when DNA began to really demonstrate its efficacy, went out to the evidence room, took the evidence from that murder, which was still unsolved, tried to extract from the clothing on the decedent any type of substance that could be tracked through DNA matching, and they did come up with DNA that they put in the national database. The DNA of prisoner Edwin Richardson matched. He was in Ohio's prison system, having been convicted of a homicide in Ohio maybe 10 years earlier. But he'd been out there probably committing crimes for years and years, and finally they had him. It was a direct match from that crime scene from 1972. It shocked me. I never realized that those kind of measures of proof could evolve. The other one was about 2 months later, and it was Stephanie Hummer, young woman, freshman at Ohio State in 1994, raped and murdered on the Ohio State campus. When they found her body, there was not much evidence, and they never even came close to a suspect anywhere. Jonathan Gravely had had his DNA taken through the criminal system because he was on probation for his plea of guilty to a fifth-degree felony non-support of his minor children. He was a divorced man, 37 years old, hadn't been supporting his children, pled guilty to the felony, got probation and paid a fine, and had a schedule then to pay off that. But his DNA was taken as part of that. I often wondered what Jonathan Gravely thought when the probation officer says, here, I got to take a mouth swab. I'm going to take your DNA. If he ever thought, oh my God, because Jonathan Gravely did not live a criminal life. He had no other crimes that we know of, none other that he ever confessed to, but he did commit a heinous murder. And he was found guilty, pleaded guilty after the DNA match occurred. And again, a remarkable solution that really occurred time and time again in the course of our work of developing DNA technology. It was in 2005, in September, that I had a phone call. I've already acknowledged Terry Collins. I had a phone call from that guy, Bill Seitz, who was a member of the House of Representatives, who I had great regard for. And that hasn't diminished, you should know. But I held him in very high regard. He called me. He said, I'd like you to do a favor for me. I have someone here I want to introduce to you by phone, and I'd like you to hear him out. His name is Mark Gotze. He's professor of law at the University of Cincinnati Law School. He's also head of the Innocence Project. With him is John Cranley, who probably none of you have ever heard of. I understand John's the mayor now. So, but in any event, he put Mark on the phone with that introduction, and Mark introduced himself and began to tell me the story of Clarence Elkins. Clarence Elkins was in prison. He'd been there about 7 years, pushing 8. And in 1998, his mother-in-law was murdered, and his niece was raped and horribly sexually assaulted. She was only 6 years old. And out of the blue, a guy who'd been a hardworking man, never in any trouble with the law, never any problems, 2 young sons, a wonderful wife, gets accused of murdering his mother-in-law. And it occurred because at one point, I think someone pressing on this little girl got her to say that she thinks it looked like her Uncle Clarence. That was as far as it goes. We know that subsequent to trial, she even said to a police officer, she tells me now, she's a young adult, that she'd said to the police captain who'd been investigating this that she really wasn't very sure about her identification. She had no certainty. She had no clear memory of it. And he said, "Oh, little girl, don't worry about this. We have so much evidence against your uncle. Your testimony is not going to convict him." Well, in reality, that's all they had. They had nothing else. Zero evidence, just her testimony. And an argument by a prosecutor that sent Clarence Elkins to prison. When I learned of the case and the details that were spelled out to me, the underscored facts were that DNA had been extracted, and I think he'd been convicted. I'm gonna let Nancy describe the DNA evidence in the extraction. Oh, my wife is recovering from a cold, but her voice is not. I mean, she's okay. I'm gonna have to do it, but she speaks much better than I do. I mean, I don't know what to tell you. I do want to get through this. There was so little evidence against him, I really puzzled over why he was indicted, because the police essentially kind of built a case out of nothing. The prosecutor continued on it. The indictment occurred. The conviction occurred because I suppose it's not entirely true that prosecutors can win almost anything. They don't. But if a prosecutor can indict a ham sandwich, I think he can convict a hoagie. I mean, literally, they have an incredible power to convince a jury who's not schooled in any meaningful way on the guilt or innocence of an individual, and they did. In any case, the case was being solved by the Innocence Project, working with the wife of Clarence Elkins. And I was learning all this. What I quickly learned is that they'd gone through a motion for new trial with DNA evidence that demonstrated that the male DNA found on both the victim, little girl who was sexually assaulted, and the victim, Melinda's mother. I never pointed that out. Clarence's wife's mother. This was Clarence's mother-in-law who was murdered. The DNA found on her was male DNA, and it wasn't Clarence. And they presented this to the court. The prosecutor fought tooth and nail to avoid a new trial motion being granted. The judge ultimately ruled that there was no grounds for a new trial, ruling that the DNA evidence wouldn't matter. You weren't convicted by DNA, she said, so why should we allow DNA exonerate you? I don't understand that one. But in any event, he was convicted. His new trial motion had been turned down 7 or 8 years later. And where did they go? They turned to the Attorney General thinking, maybe you can help us. They gave me the whole file. I gave it to our criminal justice staff of attorneys. We all reviewed a lot of the material, all the DNA stuff. And the whole group of us, like 7 or 8 lawyers sitting around, concluded, wait a minute, this guy's absolutely innocent. Why can we figure this out and nobody in the public side wants to buy into that notion? So I became quietly an advocate. Quietly for the longest time, even though I really couldn't get the attention of the prosecutor. She did not want to meet with me or talk to me about it. And ultimately, we then, kind of in the back door, began doing a lot of subsequent DNA testing. DNA testing that ultimately, with great credibility and without any question as to its reliability, concluded not only that Clarence didn't do this, but we identified, and the DNA identified exactly who had done this, because it was a guy Mark had already identified him, but we then had to confirm it, and we did, and so we had to really take a little more outspoken action. The confirmation of Earl Mann, that became the ultimate perpetrator of this horrible crime. The confirmation of Earl Mann's guilt by DNA came about as a result of, one, Earl Mann becoming a suspect in the mind of Melinda Elkins, who was devoting all of her time investigating this case to try to get her husband out of prison. Number 2, Earl Mann being placed in Clarence Elkins' cell block. And number 3, Melinda saying to her husband, Clarence, Earl Mann, who I suspect is in your cell block, if you can ever get anything containing DNA from him, do it. Clarence one day plucked a cigarette as Mann put it out in a clean ashtray. Clarence plucked it out, wrapped it in a tissue, hid it for a couple days, eventually got it off to his wife. She got it to the lawyers had it tested, and it was a direct match with the crime scene DNA. So finally we could present that without any equivocation to the prosecutor. As we were doing so formally, on the day we were poised to make that announcement, I communicated to her already all of this proof that we'd brought together, and she announced, and the court contacted me to indicate that they vacated the conviction and he'd be released that afternoon. It was really an incredible day in my career to find out that this bit of engagement, a curious engagement that really originated only because Bill Seitz called me and made that introduction, resulted in an innocent man being freed. And it felt good, but it also began for me that long thinking process about how often this happens. We've got kind of a list of things. This is where Nancy is always coming in.
I usually am here to help him with his voice.
My voice will wear out.
But I have one of those colds where you're doing fine until you get the tickle. So if I have to run out again, I'm sorry. This case was over, but it wasn't over for us. It was absolutely shocking, and it was absolutely shocking to us that everything that we had learned about, and certainly I had learned as a non-lawyer, just normal citizen, had learned about our justice system, was turned on its head. Because here was a person with no criminal record, a father of 2 young men, a married man for 17 years, a suspect within a few hours, no tangible evidence, and he is convicted and sent to prison for life. I realized if this can happen to Clarence Elkins, this really can happen to anyone. And how many people has it happened to? And oh, by the way, have we executed any people like this? And so this began a journey that led us to write the book and to do what has now been almost 10 years of study and research on wrongful conviction.
The last point Nancy made is one that haunted us after that point and thereafter and today, is how many times has this occurred across our land where the innocent person was never exonerated in time and had been convicted of a crime like this and ultimately executed. I can count several in my own mind, and we'll probably get into that as we get into some other broader discussion. But there's no question that the presence of a death penalty in a system that is flawed as our justice system can be in America, and we'll get into a little more about why it's flawed, is a very, very chancy process. It's one that is rife with error at the onset, and one that could cause tragic mistake, and we know has. The case that I want to touch on, I'm going to try to get through these very briefly, because these are the things that confirmed to me after Elkins that the system just doesn't always work properly, and through that, Nancy and I will talk a little bit about the contributors to wrongful conviction, where mistakes are made. One of them, of course, involved the case of Dean Gillespie. I was involved in that case for 5 years. Only in December 2011 was he finally freed after a State Court of Appeals order and a U.S. District Court order on 2 separate issues. But it's been a battle, and it's still not fully completed. But there was a very flawed photo lineup after 2 years after a crime that occurred in Montgomery County, Ohio. Dean was 25 years old, newly engaged. He and his fiancée just bought a home. He worked at a local industrial plant. Fine guy, popular in high school, array of friends, never in trouble with the law. Wonderful Christian family. Everything about him would say this guy should never be involved in something that's a terrible crime like this. There were 3 women actually that were subject to a sexual assault over a short period of time, 2 years earlier. What occurred here is that a workplace rival of Dean went to his buddy, the new detective, 22 years old, in a local small town police department, said, doesn't this guy, and he had the photo from Dean's photo ID that he wore on his uniform, doesn't this guy look like the sketch of the perpetrator of a sexual assault crime of 2 years ago? The detective thought he was going to win the case of the century, so he began building a case, in part by convincing the victims that this had to be the guy 2 years later. I will tell you, and we'll talk about eyewitness misidentification, that you can convince people of someone's culpability because of their appearance. But if it happens in an identification process, experts will tell me this, more than 8 or 9 months after a crime, the chance that they're going to get it right is purely a matter of chance. There is absolutely no certainty in that type of eyewitness identification. This was the only type of evidence against Dean. He passed lie detector test. Why the prosecuting attorney pursued it, I will never know. I think a clear-thinking prosecutor, and I'll basically say I think this prosecutor was not clear-thinking, a clear-thinking prosecutor with all the shabbiness of the evidence here should have basically said, we're just not going to take it. We're not going to do it. We're not going to risk the opportunity for mistake. But they didn't. And so Dean was convicted, served 20 years. He's a fine man. It should have never happened. Michael Green, a case I learned about in my early days, and these are kind of awakening moments for me as the state attorney general. But Michael Green, in a case I learned about early in my service as attorney general, another flawed photo lineup. I'll tell you, we'll talk a little bit about wrongful identification, but here's one where the police agency, which happened to be the Cleveland Clinic Police Department, investigating the rape of a patient who was staying at the adjacent hotel while a young woman undergoing cancer treatment, was raped by what she described as a small of stature African-American male who, when he left, called himself Tony. And so one of the police officers said, hey, remember that guy who just left working here? He went somewhere else. He worked in the kitchen. His name was what was it again? I think it was Tony. Well, his name was Anthony Michael Green, but he went by Michael. He never used Anthony. But they went immediately and got his photo from the employment file and put it in a six-pack of photo for an array that afternoon with the victim. She looked at them all and said, none of these, absolutely none of them, represent or recognize, look like the perpetrator of this crime upon me. And so they said, okay. Next day they invited her back again, so we have some new photos for you to look at. They had 5 new photos, and a 6th photo was of Michael Green again. They put it back in there for the next day, and of course she looked and looked and looked, as I understood it, and she said, that guy looks familiar. Well, of course he looked familiar. She saw his picture the day before. But with that identification, they had their case. They never turned back. They never investigated it further. They just indicted him, convicted him, and after 13 years, DNA exonerated him. It's tragic when you see these kind of things that have occurred, in part, I got to tell you, because of the recklessness of the police agencies that don't stop to think about the weakness of the evidence or the risk that the evidence is not very reliable. We will talk about reliability of evidence in a few minutes.
Just a footnote on that case of Michael Green. Connie Schultz, a national journalist who was writing for the Cleveland Plain Dealer, did a long series on this case, and she didn't realize that one of the people reading about it was the actual perpetrator. And so at the end of the series, he really had always regretted this awful crime and went to the police and said, I was really the person who did that. And then they did the DNA testing, which confirmed it.
Interesting outcome. And this is after Michael had just been exonerated. Moving on to Ray Towler. Ray Towler is probably the sweetest guy you'll ever meet. He was just out of the Army, where he'd served 6 years, was a non-commissioned leader officer, had his own jazz band, and was an accomplished watercolor artist. He decided not to continue in the service. They wanted him to re-enlist. He actually said, give me 6 months to see if I can get the jazz band going. I may come back. Again, a wonderful American who served his country with distinction. He was looking for good places to do watercolor work and driving through the metro parks, where he was stopped probably before driving while black. I mean, that's kind of what it was, in an area that is very white on the west side of greater Cleveland, right near where we were living at the time. And so I was familiar with the case when it was evolving in 1981. In his case, the police just said, gosh, would you mind if we took your picture? We've had a crime that occurred here, and he said, well, no, go ahead. He had nothing to concern with, so we took his photo. The crime had occurred the day before. It was two young children who'd been sexually assaulted. They were white children. They described the assailant as a black man. They never indicated in any way that the black man had a big bushy beard like a black Santa Claus. They didn't say a word about that. They just said he was a black man. Well, Ray Towler had, and you can see it in his picture there, he's always had a big bushy beard. The police showed them the photo, and they said, well, yeah, that's the guy. Again, I would suggest to you that these children had not had a lot of experience seeing people of, of a different race. And so they identified him. Based on that, he was convicted. He spent 28 years in prison. When DNA ultimately exonerated him, he was absolutely innocent of this crime. And he's probably the most forgiving man I've ever seen. He just basically says, and he does what we do. He goes, you'd probably enjoy hearing him much more than you enjoy us. But he goes around and talks about wrongful conviction and what happened to him. Really an outstanding guy who, invested 28 years of his life for something he never really had anything to do with. Each of these, Nancy?
Okay, so Jim has talked about 4 people that were wrongfully convicted in Ohio, and all of these cases in one way or another actually touched him. There have been 40 recorded that we've identified in Ohio, wrongfully convicted persons. Over the years, many other people have identified the principal contributors to wrongful conviction, and the thinking then and still is that if we can address these contributors, we can reduce wrongful conviction. But we've also evolved to realizing that we need a culture change. We have sent a message to be tough on crime, and the people we elect are afraid to second guess. They're afraid to appear to be soft on crime, and it is causing tragic results. We know that the prison population has exploded. There are many reasons that we need this, but one of the post-DNA things that we like to talk about is before DNA and before we realized that people were being wrongfully convicted, prosecutors often felt their job was to gather the evidence and then present it to a jury and let the jury decide. That was their job. But really what we've discovered is that the juries are not prepared to evaluate the kind of evidence provided them if it's unreliable evidence. And so prosecutors have to really be our ministers of justice, seek the truth, not just convictions, and they need to feel in their hearts that when they're presenting evidence, it's reliable. Not that it just makes a case, but it's reliable evidence.
These items that are shown here kind of point out some of the unreliable of some of the evidence. But let me skip ahead so we can get into the capital punishment portion of the program. When we talk about innocence, we're not talking about people that are determined to be innocent because of a legal technicality. We're talking about people who are determined to be actually innocent. I mean, they were proved to be actually innocent. Someone else did the crime. DNA has been a big part of this process, and it's been utilized since 1989. The Innocence Project really kicked off these types of investigations beginning in '92. 317 have been exonerated by DNA since the start of the Innocence Project. 18 of them served on death row. The average service time was 13 years. The true suspects and perpetrators were identified in more than 40% of the cases through DNA, but there's much more to it, and the next slide will kind of allow us to continue on it. Go ahead.
In addition to the DNA-proven exonerations, last year the National Registry of Exonerations was launched. It is a project of University of Michigan Law, and this database recognizes 1,430 exonerations. Exonerations are a proxy for wrongful convictions, but they're a weak proxy. They're basically, these are the people who have been wrongfully convicted, and we have recognized it, identified it, and done something about it. And they are a small fraction, we know, of people who are wrongfully convicted. Among those are 633 who had been convicted of murder. That's disproportionate for sure, and the reason there's disproportion there is probably twofold. One, often these murders were really a rape murder, so there was biological evidence that could turn it over. And secondly, we tend to put our resources on capital cases because everyone intuitively knows these are the ones we really, really can't make a mistake on. And yet 633 people were convicted of murder and then exonerated. Of those, 108 had been sentenced to death. The person who has made it his life's work trying to understand and recognize how often wrongful conviction occurs, one of many, but one of the leaders is Sam Gross, University of Michigan law professor, and founder of this database, who's now co-director of that. And he has recently he's been the lead writer on a recent study that showed that 4.1% of those convicted of capital crimes are likely innocent. We've had 138 prisoners. 1.6% of those sentenced to death have been exonerated. The question is, how many were not exonerated? How many could not prove their innocence, which is extremely difficult to do? Sam Gross says with an error rate of 4%, it's all but certain that we have executed several of the 1,320 people executed since 1977. Many of us feel pretty strongly about some names in particular. Todd Willingham in Texas was executed after being convicted of an arson fire that killed his 3 children. He was convicted almost exclusively on forensic evidence that would indicate that certain burn patterns would indicate an accelerant. That science has now been totally debunked, and unfortunately it was after his execution. There are hundreds of people in this country in prison today because they were convicted on that same forensic evidence. And most people are familiar with Troy Davis in Atlanta, but there are many others that were not so high profile. And so we feel very certain that we have in this country executed innocent people.
Oh, keep going.
Okay.
I get to shut up.
If we look at the 633 people who were convicted of murder and then exonerated, we did some research on what contributors of the main contributors were in those cases. And you'll see that many cases have multiple contributors. But for example, eyewitness misidentification, one of the big ones, was present in 157 of these cases. False confession, believe it or not, was present in 128 of these cases. Perjury, or false accusation, is the leading contributor in cases of murder. What we've discovered through this wonderful database, and it's a very deep and rich database with information on each case, is that each crime has maybe a different configuration of primary contributors. And for murder, it's false accusation, often the actual perpetrator basically pointing the finger at someone else and then getting relief for doing that. Official misconduct was present in 380 of these cases, misleading forensics in 142, and ineffective counsel in 130.
I want to ask you to, this is good, because we want to talk about the contributors a little bit more. What we've done here, and we've done this as we kind of examine the recommendations of the task force, and we had an opportunity to present. We talked about our concern about innocent people being convicted, but in response to a lot of discussion that evolved around these contributors that we talk about, including the contributors as we've identified them in the book False Justice, we've kind of looked at some of the proposed changes in the law, the proposed recommendations, and what they're directed at. Number 17 among the recommendations would be involving a recognition that eyewitness misidentification occurs. Those numbers are the instances of these 6 contributors being involved in the 1,430 exonerations. There's a lot of material here, but it's kind of our little noodling as we go through all of this. Eyewitness misidentification underscores the reality that an eyewitness is not always right, and they are responsible for a lot of convictions. In the DNA exonerations through the National Innocence Projects, 75% of the convictions that were proved wrongful by DNA were convictions that were based largely on a bad eyewitness identification. In the case of false confession, as a lawyer, as a prosecutor, I never would have believed that an innocent person would actually confess. But so many of them have. We look at Chicago and the abuses of their police department. We jokingly in the Innocence world call it the false confession capital of the world. They have young people who are confessing all the time because they keep them in a room for 16 hours. They basically say, this is the end of your life as you know it. We've got all kinds of evidence against you. You took a lie detector test, you failed, when in fact they may not have failed, they may have passed. All the things that would spook a 17-year-old. And then they say, if you'll just sign this admission, you can go home. They sign the admission and they never go home again. And that's what happened to many of them, not just Chicago, recently the Central Park group of young men that all of them were basically convicted based on very, very faulty confessions, but confessions or admissions or something nonetheless. It's kind of shocking when you learn about it, especially from my standpoint, because I never believed, once again, that if you're innocent, you're going to confess, sign an admission, plead guilty, but it happens all the time because they begin to think they have no other avenue. Perjury and false accusation. The things that bother me about false accusation is it's often the perpetrator who makes the accusation against someone else, but even more than that, it can also be a snitch, a person whose testimony has been elicited, and it always sounds so hokey to me. You say to yourself, to the prosecutor, how could you buy this? This guy tells you so that he can get a better break that he was sitting in a holding cell with defendant XYZ, and defendant XYZ confessed to the entire crime to him, and he's willing to testify to that. You really believe this guy? But that happens all the time. And so a whole body of convictions that have been determined to be wrongful were based on snitch testimony, perjured testimony. It's tragic when you think about that. You say to prosecutors, your job is to really gauge the reliability, not use it if it seems phony at the onset, but too often they do use it. Official misconduct has been part of this. In fact, in the great body of wrongful convictions, the 1,430, fully nearly half involve some measure of police or prosecution misconduct. Misleading forensics we've talked about. It is remarkable that we use science, and in so many cases, Michael Green's is a perfect example. In Michael Green's case, among the other things beyond the eyewitness identification, which was faulty, they used hair testimony by a forensic hair expert who testified that he studied a hair taken from the crime scene, a male hair, and a male hair specifically plucked from poor Michael Green's head, and they were a match of sorts. That really can convince a jury, and we now know that that kind of science doesn't work. The FBI will have learned, and they've learned, that they convicted hundreds of people based on hair matching evidence, and now the experts say you can't demonstrate that there's any scientific basis for that. It has happened too often, but now there's a lot of people getting reviewed and released. There's still thousands of them out there convicted on hair testimony. That is just faulty science. Again, another area of mistake that we now are aware of, and what we're calling upon prosecutors to do is if there's any question on the reliability of forensic evidence, don't use it. The risk of mistake is too great. The other one, the last one, ineffective counsel. I think you all know what that means. Tragically, there are in very complicated cases, too often there are attorneys who really aren't schooled to the degree they need to be able to properly defend these individuals. And that just happens. What can I say? Nancy?
I just want to point out that what we did is look at the task force recommendations, and you can see the number of the recommendation next to the contributor. And so, I know that the senator knows much more how those deliberations went. All I know is that the recommendations really did address the principal contributors to wrongful conviction. And to that, I thank the senator and everyone else who served on the task force. I think you must have done a very comprehensive job of looking at, and there were other things, equity in applying the death penalty. Certainly a number of different concerns, but I feel as if wrongful conviction was addressed, and I'm very pleased with that. I just want to conclude with the story of a recent exoneration of two people who had been convicted of murder. This is not the most recent. There's been at least one other since then, but this was August 2nd, not 6 weeks ago. A North Carolina Superior Judge, Doug Sasser, declared Henry McCollum and Leon Brown, two mentally disabled half-brothers, innocent in the 1983 rape and murder of Sabrina Bluey, age 11. Both of these men had tested at one point at about IQ 50. They were arrested at age 19 and 15, and they were convicted solely on a confession which they repudiated immediately and for the rest of their lives claimed was coerced. Finally, after 30 years, DNA implicated another man who, incidentally, lived 3 blocks from where the little girl's body was found and had confessed to a very similar crime, remarkably similar, that occurred even before this trial had been completed. So you would think that 2 murders like that in a small town of 4,000 might have raised a flag when the second one occurred. This case became, these gentlemen are now finally free, but this case sort of became the poster case for those who supported the death penalty. Supreme Court Justice Scalia used McCollum as an example of a case and a gentleman where you could hardly argue against lethal injection after a heinous crime like that. And as recent as 2010, a Republican candidate for office used his mugshot when he was a teenager coming into this against his opponent, who he called tough on crime. The prosecutor involved in this was actually profiled in 60 Minutes as the most deadly prosecutor in the country because he so frequently went for the death penalty. I think that the task force actually addressed many of these issues. In 1994, I guess it was okay to execute mentally handicapped people. I think we've overcome that in part, but the task force did address that. It also addressed the biggest problem here, wrongful conviction. We have a lot of work to do. We have to seek a culture change. And until that happens, it is not safe to have a death penalty in this country. Thank you.
You know, as I wrap up over 30 seconds, I want to point out that in the McCollum and Brown case, it is interesting that this most deadly prosecutor in the country still says he thinks they're guilty. They just don't get it. I mean, I just can't understand it. We really appreciate your engagement on the issue of the death penalty. There's no question in my mind that it's got to be re-examined. Nancy and I in the 1970s were always involved in policy. We were involved in our church. We were involved in our faith. We talked about major issues, and we came to agree to disagree. Nancy has always been against the death penalty. I was one who said, in a democracy, for those who are most heinous criminals who commit the most heinous of crimes, obviously murder and torture and all the things that could be related to that murder, I think it can be warranted as a punishment. However, in the course of my many years in the world of public policy, in my service as Attorney General, I came to believe that the grounds under which I supported that measure in 1981, that it would be a deterrent, that would save the public money, it would assure public safety, none of that is true. And so in years, most recent years, I came to believe that as a nation, we should not undertake the death penalty. It's too rife with danger in creating a non-reversible mistake. 3 times in my most recent career, feeling as I do that Ohio could risk a mistake, and Ohio would be devastated by proof of a mistake in execution in our state, I've gone to governors who, because I'm involved in in the public world a little bit. I know all of our governors over the last couple of decades, I suppose. As I was getting ready to leave office, I went to Bob Taft and I said, I'm Attorney General. John Spurko has been convicted. I don't doubt he's probably guilty, but I'm not 100% sure, and I don't think the state should undertake this unless you're 100% sure. Bob was very understanding. At that point, I requested a reprieve for 90 days, which the governor granted. I kept doing it. I did 7 90-day reprieves, and we kept looking for DNA, all the way till the end of my term. At that point, it fell into the hands of Ted Strickland, and John Spurko was scheduled to be executed in February after Ted took office. I contacted Ted. Hey, I left office, Ted, but I'm concerned about this case. And God bless him, Ted kind of took that to heart. And my point was the same. We may support the law, we may support the death penalty, but you got to be sure. We got to be absolutely sure. This guy was convicted based on circumstantial evidence without any corroboration. We've never executed somebody on that framework. There's always been far more. So Ted granted life without parole. He reduced the sentence from death. I had the same issue arise in my private life with a man named Kevin Keith. And I went back to Governor Strickland again. I don't mean to kind of lay this on you again, but Kevin Keith is probably guilty. But it's based on an eyewitness, and I think it's real shaky. And so, again, I think Ohio could be making a mistake. Bless his heart, Ted Strickland commuted the sentence of Kevin Keith. When John Kasich took office, he said to me one day, because he'd asked me, at that point, I've not talked about my most recent public life. Before I retired, I was Chancellor of the Public Universities. Governor appointed me to that. And he said to me one day when we were traveling together, he said, if you ever have any doubt in cases, I know you look at all these cases, let me know. And I have. And in one of the most significant ones, he did grant life without parole to a person that was sentenced to execution. So, I don't mind being an advocate in this front. My advocacy, though, is premised on the fact that, Lord knows, our society can never make a mistake, and I hope we never do. Or again, I know we have already, but in Ohio, I hope we never do.